So Logan was a true victim. She was a helpless victim. She was not an intended target.
And I am Logan Haley Federico's father, better known as Dad or her hero. Unfortunately, that day, I could not be her hero.
22-year-old Logan Federico was randomly shot and killed during an alleged home invasion near the University of South Carolina. Police say Logan had just returned to the house where she was staying when she came face to face with an intruder. Columbia police believe she was one of at least 10 victims targeted by the same man, a suspect accused of breaking into homes, stealing cars, using stolen credit cards, and eventually setting a house on fire. Now, friends and family are left mourning a young woman whose life was cut short.
And please keep my daughter and your family in our prayers.
I'm your host, Kennedi Walker, and I'll walk you through the details.
The Dickey who took my daughter's life, this is from her. You can't kill my spirit. You might be able to kill my body, my physical, but you cannot kill my love that my family and friends shared with me.
Stephen Federico delivered an emotional message to the man accused of killing his daughter, Logan.
My memories made with my daughter and my family and her friends will never die.
Logan Federico was staying with friends near the University of South Carolina last Saturday when she was killed during a reported home invasion. Police say when Logan returned to the residence after a night out, she allegedly encountered 30-year-old Alexander Dickey, who was breaking into homes, including the one where she was staying.
Breaks into one of the Cypress Street homes, and he steals keys to a vehicle and several items, including a firearm, after he was rummaging through rooms. The suspect also breaks into the home next door. These houses are side by side. And he steals several items, including a wallet and credit and debit cards. While in this residence, we believe that he enters a room where Miss Logan is located and fires a fatal shot.
Logan was discovered by her friends later that morning. Investigators say the man accused of killing her went on a multi-day crime spree, stealing a car and using money and items taken from homes.
He uses stolen credit and debit cards to go to multiple stores in Lexington County. He ultimately drives to Saluda County and attempts to make additional fraudulent purchases. While at a location in Saluda County, the stolen vehicle breaks down. This leaves Dickey somewhat stranded. He then calls for a tow service to move his stolen vehicle from Saluda to a residence in Gaston County, which is in Lexington County, and this is a home of another female acquaintance.
At this time, police had identified Dickey as a person of interest and began tracking transactions made with the stolen credit cards. Investigators say they eventually located him and surrounded the home where he was staying. Dickey allegedly fled the scene, stole another car, and reportedly crashed it a short time later. According to police, the following day, he returned and broke into the home of the same female acquaintance. As officers attempted to get him to surrender, they say Dickey allegedly set the home on fire.
As law enforcement is giving him commands, the house or the residence becomes engulfed in flames. It's set on fire. Dickey is extracted through a window, taken into custody by the Lexington County Sheriff's Department, and he was taken to a hospital where he was treated and released.
Dickey was arrested and charged with multiple crimes, including murder, burglary, arson, grand larceny, and more.
He's a true convict and deserves to be in jail for the rest of his life.
Logan's father says her life was cut short before she had the chance to fulfill her dream of becoming a teacher.
My daughter, I cherished. She was a strong, fun, loving individual who did what she wanted to do and was spicy. She was the biggest Taylor Swift fan that I've ever seen. I took her to the Taylor Swift concert myself, and then I became one.
Now, all he says he has left are the memories they shared, and he says she will never be forgotten.
She will live on forever. Maybe not physically, but spiritually. And please keep my daughter and your family in our prayers.
I want to thank Odoo for sponsoring this news package. Odoo is an incredible all-in-one business management software that provides you with a range of applications. One of my favorite Odoo applications is their sales tool. The Kanban pipeline is a game changer. Whether you're working with leads or full-blown opportunities, you can visually track every stage of your sales process. Just drag and drop to move deals forward. It's fast and honestly kind of satisfying. When it's time to send a quote, it's literally a couple of clicks. And the reporting is super clear. You get a live view of your pipeline, conversions, and what's working so you can focus on closing, not guessing. So right now you can get a free 15-day trial of Odoo's all-in-one business solution and see how it can make your life easier. Check it out at www.odoo.com/lcnewscrm. And joining me to talk more about this is criminal defense attorney Tyler Bailey. Tyler, thank you so much for coming on today. Let's just jump right in. Can you walk us through each of the charges Alexander Dickey is facing and what they mean?
Well, he has countless charges here. There's over 10 victims. There are some property crimes from breaking and entering, but the main crime that everybody's aware of and holds the longest penalty is his murder charge. And based off of the law here, if it wasn't probably in the county it's sitting, death penalty would likely be on the table. But clearly, he's likely going to receive a sentence if convicted of life without parole.
And so what's the potential sentence, though? Like, how many years are we thinking? So life, the whole life, and why not death penalty?
Well, the death penalty, you need to have a unanimous consent to implement the supreme penalty, better yet known as the death penalty, for that to be the situation. So that's a lot of times why prosecutors may not put that on the table. And in this case right here, given the number of charges he has in the murder conviction, he will likely receive just to send a message, consecutive sentences if he's convicted for the max of each offense. So you're looking at something, 70, 80 years, if not more. But really, is the big charge will be life without parole for the murder conviction if he's convicted.
Could he face federal charges in addition to the state charges?
I don't see any federal charges being brought here. I mean, there probably could be some use of the credit cards that he allegedly stole from one of the homes prior to this incident. That could be considered a federal crime because it's just the nature of using those transactions on in stores and things of that nature. But no, the murder charge here is a state murder charge. It's a local case that happened in Columbia, South Carolina. I do not see the federal government picking this up.
Now, police describe the suspect as a, quote, true criminal based on just past convictions. How do prior offenses factor into this case?
Prior offenses go a long way when it comes down to crimes being enhanced. So, for example, we talked about how long his sentence could be, given the nature of his criminal record regarding breaking and enterings and financial car theft and using other people's credit cards and identities to do smaller petty crimes. Those will be enhanced. So rather than 5 years, it could be 10 years per offense. And given that he has a prior record, he likely will not receive any sort of plea deal that any defense lawyer would even consider that he take. And he's just not going to receive any mercy from the court system. And certainly at sentencing, if he's found guilty, the judge will take his prior record in hand when initiating a sentence. And also being career criminal affects the likelihood of somebody receiving a bond. In this case, it seems like he's had multiple interactions with the law, and the likelihood of a bond being brought at a later date, if a defense lawyer want to make that motion, will probably be denied.
And like how you said, there's been a lot of past convictions, so many mugshots, so many just charges and accusations against him. How does a person that's described as a true criminal even have the chance to do something like this again? Do you think that this is just some type of failure somewhere? He was able to slip through the cracks?
Most people don't go to jail for life in prison for breaking and entering. let's say if it was auto break-ins, those smaller petty crimes that really do make people feel unsafe and it really makes people feel violated, it just may not rise to the level of 20, 40 years of a sentence. So there are people who have been convicted who may have done 2, 3, 4 years for these crimes, and then they're back out. But under the laws, generally, there aren't those max penalties unless they're enhanced penalties. When somebody has multiple of those offenses, then, like I said earlier, it can go from 5 to 10. The likelihood of somebody receiving consecutive sentences for something like 20 years for breaking, entering prior to doing something like this is unlikely. And so the system as a whole, you have people who are sometimes career criminals, but then maybe they get involved with drugs, have substance abuse and other mental health issues, and then unfortunately something like this happens. So I understand the initial reaction that how could somebody be back on the street and they've had a rap sheet in the past, but a lot of times their past rap sheet isn't murders or attempted murders or violent crimes. Sometimes it's nonviolent crimes and they're just repeat offenders. And unfortunately, they've done something now that does not warrant them ever seeing the light of day.
How will law enforcement prove premeditation or lack thereof in this case, in a home invasion murder?
The biggest thing I think is going to make the law enforcement case easy, but unfortunate, is that he broke into another home right before this one that was next to it. All right, and then he was also on a crime spree before he broke into those two homes. Now, I'm saying allegedly because he's, of course, innocent to proving guilty. But until they prove that he's broken into those two homes, which there seems to be evidence that he did, it's going to show that's premeditated. He grabbed a weapon. Now, he may say, I did not intend to shoot her, but he intended to grab the weapon. The likelihood of somebody being inside a home at night isn't hard to prove. And the likelihood of somebody, unfortunately, being murdered in the breaking and entering when somebody's holding a shotgun at night or early morning hours is not unforeseeable. And so I think that's what the court or the prosecutors involved and law enforcement officers will use to prove premeditation.
Could his behavior after the shooting be used to demonstrate a consciousness of guilt?
Definitely. I mean, it's not anything after a crime outside of probably immediately turning yourself in. Still, it's consciousness of guilt. But here, he was on a crime spree. I mean, the fact that he was on a crime spree, I believe that the prosecution does not have a hard case to prove here. Richland County jury in Columbia, South Carolina will likely be unsympathetic to the accused here. It is a long uphill battle for the defense.
And police say that these alleged crimes happened in, multiple counties, right? So what are the challenges that prosecutors face when trying a case involving multiple crimes across multiple locations?
Well, there'll be collaboration here. So the counties that occurred to are neighboring counties. You have Lexington County, you have Richland County. They're right by each other. During this press conference, the Lexington County sheriff was also present. And so the law enforcement agencies here frequently collaborate on things. I'm sure the trial of this case, both of them, whether it's tried first in Richland or tried first in Lexington County, they'll collaborate on that. And any sentencing that goes down, if there is a plea offer that's accepted by the defendant, will likely be coordinated as well. So I don't see lots of challenges here, but there'll just need to be collaboration between the two agencies and also the victims, because they will want to participate in this trial.
What possible defense strategies might Dickey's attorney use? If you were defending him, how would you go about this?
Well, I think the only strategy his defense will likely use is going to be maybe insanity, right? Or he just doesn't have the capacity to stand trial. It does look like he has some drug history based off of just the nature of the charges that he has. And so I think that's the best chance that the defense has, looking at mitigation, whether it's substance abuse challenges, mental health challenges, something that can be used to garner some sort of sympathy in sentencing. And if going to trial, you just have to be aggressive. You have to attack everything. You got to do what you signed up to do for your client. Attack every piece of evidence, see if it's admissible or not admissible, cross-examine law enforcement witnesses and any other parties vigorously, and hope the best when it goes to a jury.
And how exactly would that work? Would the suspect have to, see multiple doctors, get interviewed several times? How would you go about making that stick?
Yeah, it'll need to be experts that are involved to of course, evaluate him and see if it sticks. And it's ultimately up to a judge to see if he's competent to stand trial. So that's really that's one option that a defense lawyer could do. Likelihood here, I'm not sure, based off just what we're seeing. He obviously broke into one home, broke into another home. Right, this shows that he had some reasoning and logic in his actions. He allegedly stole entered into a vehicle and used other people's identification, credit cards to conduct transactions. That shows that he has some sort of sense. So these are uphill things, but an expert could evaluate him and make that opinion, but ultimately it'll be up to the court.
Could the defense argue accidental discharge of the firearm?
That's likely what they will argue, I'm assuming. But here you have to look at it. I mean, when you're inside a home breaking and entering, the likelihood of you running into somebody at night who may be trying to defend themselves, which they have the right to do in their home, and a offender having a firearm and discharging it, that is highly likely. Proving that it was not intentional is going to be the harder, I think, hurdle, because it'll be different if the gun actually discharged, it was his hands, it was his pocket or something. But here it looks like the evidence showing that the shotgun was in his hands, pointed at the victim when she was murdered. Terrible, horrendous, and she was a young, beautiful soul. Wish the father and family the best. And a defense lawyer will try their best to, of course, prove these items or ensure that the prosecution proves each item beyond a reasonable doubt. But it's looking like an uphill battle.
And I watched the press conference that the police chief put on, and one of the reporters asked him, but we didn't really get a clear answer. Like, okay, so during this happened maybe 2 or 3 o'clock in the morning when the alleged shot, went off. But the first 911 call didn't happen until 11 a.m., like hours and hours and hours later. Why do you think that is? And why do you think, police haven't really given an answer to why that happened? Because if a person got shot at 3 o'clock in the morning and you would assume that, a gunshot is loud, why wouldn't someone call for help immediately instead of waiting hours later?
I can't speak to why the law enforcement did not give that answer at this moment. I'm pretty sure it has something to do with protecting their prosecution, to ensure that they're able to present this case well to a jury later on. But just looking at the age range of the victims and the victim who lost her life, the time of night, the week, this is a college town. People could have been out hanging out beforehand, assumed somebody's asleep and wondering maybe why they haven't woken up, and then possibly have found out later on. There's a chance that they didn't hear the gun discharge. You got to take the totality of circumstances, and there's countless reasons as to why I think it could take from 3 o'clock in the morning to 11 a.m. People sometimes, if they're out that late, they may sleep until 10 a.m. It would be different if it was 3 days later and they were up there and they saw her in the bed, and that could seem suspicious, but there's no suspicion here that I see.
But you don't find it suspicious that someone waited 7 hours? Like, even for the hardest of sleepers to not hear a gunshot in the middle of the night?
Well, first it's assuming that they were present when it happened. They may have not been there because it slept another. It's not like it was a husband and wife situation where I don't know if they shared beds. I don't know. She was, I believe she was visiting here, so she wasn't from here. She could have had her own room, and they could have been out hanging out, then got home late there, and then they found out in the morning. If you're out to 3 a.m., 4 a.m., and then wake up at 10, then wondering where your friend is, why she hasn't gotten up, that could lead to be a reason. And it would be different if there was, there wasn't, I would say, another person who evidence is showing that they more than likely could have been involved in the crime, which is the person who was arrested. I don't see any other indicators of possible suspects, just given the break-ins, the two homes next to each other, and the other evidence that our police department has referenced on the press conference.
True. Yeah, that makes a lot of sense. Just wanted to ask. Going back to the suspect here, going back to Mr. Dickey, is it possible the defense could push for a plea deal, or in this case, do you think it probably isn't likely? It's more of an open and shut case.
Highly unlikely, I think. When you have crimes like this that occur, the community is highly involved and understands what's going on, and generally, law enforcement departments and prosecuting agencies want to send a message here. And so, unless the plea deal is just pleading outright to the max of everything, I don't see the defendant being offered a plea deal that would justify not trying this case, to seeing if you could, preserve some things for appeal, possibly receive a new trial, or maybe there could be a deadlock and a mistrial. I mean, the defendant would have a better chance of going to trial and trying to attack every piece of evidence than they would just pleading out to a sentence that's something like 65 years.
How likely is it that Mr. Dickey will testify in his own defense?
I think it's highly unlikely that he'll testify in his defense. I think, if anything, the nature of what the defense would try to do here is attacking the evidence, objecting to certain evidence being admitted, preserving issues for appeal, doing things that a good defense attorney would do in a case like this. Putting your defendant like Mr. Dickey on the stand with the facts and evidence here and his rap sheet, I don't think that would be in his best interest.
In your experience, what are juries most likely to focus on in a case like this?
I think they're going to just focus on totality of circumstances, what happened and transpired prior to the murder occurring. I think the prosecution would do a good job in trying to outline the timeline of this, the other crimes, the other breaking it, entering, where the firearm was retrieved from, unfortunately, the location of the murder, blood spatter evidence, things like that, I think, is what the prosecution will focus on and outlining for the jury. And I think the jurors would just pay close attention to all of this and try to make a finding what they think is in line with the case that was best presented before them.
Now, you've mentioned a couple of times, this has been getting a lot of media attention. The police are most likely going to try to want to prove a point here. Could this case be moved to another jurisdiction due to just pretrial publicity?
I also think that's highly unlikely. Case of being moved to alternative venues is generally not that does not happen that much, and you have to be talking about a case with just broad, wide notoriety. There has been some media attention to this, and a lot of media attention to this, but it's not up to the level of, for example, the O.J. Simpson trial, right? That occurred years ago. And I think that wherever, if it was Lexington County or another county neighboring, it could be a worse venue. So I highly doubt the defense would want the venue changed here.
And trial timeline, what are we looking at?
It's too early to say. It really is too early to say. They'll have to go through the evidence on their end. There'll, of course, be plea negotiations, but I don't think this would be a case that lingers out there forever. I think law enforcement and the prosecutor's office is going to be pretty aggressive in seeing that this family gets some sort of justice, and the defense will try their best to prepare in the time that they have. But I don't think this will be a case the wheels going to be turning too slow with.
All right. Well, this is a case that we will be following closely. Tyler, thank you so much for joining me today.
Thank you.
Police say Alexander Dickey has an extensive criminal history. Shortly after he was arrested, he was denied bond. For Law and Crime, I'm Kennedi Walker.